So let me begin by thanking the College of Charleston and the Center for Public Choice and Market Process, as well as Dr. Pete Calcano, Max Pogolov, and B. McDonough for making this event possible. We'd also like to thank the John Templeton Foundation for their generous financial support. We're also extremely grateful for all of our speakers that are here joining us this afternoon. So first, I want to introduce Mark Labar, who is a philosophy professor at Florida State University, John Hasnas, professor of business at Georgetown University, and Michael Thomas, professor of economics at Creighton University. I also wanted to be sure to mention the other IHS staff that we have here this weekend. So we have James, who's working at the table outside that you met, as well as Kelly Barber. So please feel free to ask them any questions that you have about anything going on this weekend. And lastly, I want to thank you guys. Very few college students are willing to give up their weekends to sit in the classroom and learn more about these ideas, so we greatly appreciate you joining us. Now, I'd like to tell you a little bit about IHS and why we put on weekend seminars. So at IHS, we believe that ideas have the power to change the world. We also believe that at their best, universities are important incubators of academic freedom and open inquiry. Therefore, we put on seminars like these to give students and professors opportunities to explore the big questions related to politics and economics in hopes that it will lay a groundwork for a free society. Throughout the seminar, one theme will tie everything together, that theme being liberty. Classical liberalism is a political philosophy that holds liberty as its highest value. So what do I mean by liberty? We define liberty as the intellectual tradition of individualism, free markets, and limited government. At this seminar titled Classical Liberal Perspectives on Law, Philosophy, and Economics, we'll be exploring questions like, do we have a right to free speech? Should we care about equality? And do laws that are not good for society often get passed, and why? Our founder, F.A. Harper, an economist at Cornell University in the 1940s, lived through many dark events that made him think on these classical liberal ideas and questions. Events like the poverty of the Great Depression, the devastation of World War II, and the rise of fascist regimes in Italy and Japan. Harper, or Baldy as his friends affectionately called him, was very interested in trying to gain a better understanding of how these events occurred so they could be prevented from happening again in the future. Baldy found some of his answers in an exciting and controversial book that was published near the end of World War II. This book was called The Road to Serfdom by Friedrich Hayek. Hayek argued that the ultimate cause of World War II had been the rise of all-encompassing collectivist governments at the expense of individual rights and freedoms. Harper assigned this book to his students at Cornell. Unfortunately, Cornell administrators deemed it too controversial to be taught and told Harper he had to remove it from his curriculum. Harper was shocked by this breach of academic freedom and resigned from his position at Cornell in protest. Baldy went on to found a new nonpartisan institute called the Institute for Humane Studies. He called it the Institute for Humane Studies because he believed that the humane disciplines, so economics, philosophy, history, political science, and law, were essential to protecting and advancing the ideas of liberty. For over 50 years now, IHS has been working to achieve two purposes. One, to facilitate research on the vital problems of human liberty, and two, to educate and develop the talents of young persons having outstanding promise. I'll go on to give you guys more specific examples of how we do this later in the seminar. Before I move on, though, I want to add that when I was an undergraduate, I attended a weekend seminar like this, as well as a whole slew of other IHS programs. And without those programs, I wouldn't be standing here in front of you today. So I hope you guys are as excited as I am, and I'm more than happy to share with you the things that I did and the things that you guys can do after this seminar to get more involved. Before I turn it over, I want to cover a couple housekeeping items. So number one, in your packets, you'll find a brief schedule of what we have going on tonight and tomorrow. Please reference all of our start times. At the seminars, we try to make a point to start on time and end on time, so please be in your seats and ready when we're going to begin. Next, please wear your name tags at all times. We want to get to know you better throughout the weekend, and we want to know how to address you, so please have your name tags visible for us. No phone calls during the seminar, please, so take the time to turn your electronics off now or put them on silent. Next, everything is off the record here, so please don't write or blog about something someone else has said without giving their permission. Next, please be respectful of others' viewpoints. You guys come from a variety of different perspectives, and we want to foster a fruitful discussion. So please be respectful of one another while you're talking about the ideas presented at the seminar this weekend. Next, no underage drinking. There will be alcohol provided at the social, but please don't partake in alcohol unless you are of legal drinking age. And lastly, please no food or drink in the auditorium. So there's coffee and things outside, but please make sure that you keep them outside in the future. So to sum up, we're counting on each of you to join us in shaping the discussion over the next few days. The faculty lectures will serve as a sort of springboard, but you guys should feel free to challenge the ideas presented, take them further, and take them in a new direction. We have a wide range of disciplines represented here, and each of you has a unique perspective to contribute. So I very much look forward to hearing your thoughts throughout the weekend. And now I want to turn it over to B. McDonough, who is going to tell you guys more about the Center for Public Choice and Market Process.
Thank you again for being here. My name is Beatrice Maldonado, and I'm a professor of economics and international studies here at the college. I'm also serving as the interim director for the Center for Public Choice and Market Process this semester. So welcome everyone to our first public talk for the semester for the center. And we couldn't have made this public talk possible without the help of our IHS colleagues and our three speakers who are, well, John Hasnas is going to be here for the current talk, and our other two speakers for the week in Exploiting Liberty. So we're really thankful for all the effort that everyone has put forth to make this possible. At the end of the talk today, we will put up a survey, or a link for a Google survey. Please take the opportunity to fill that survey out to give us some feedback about the speakers. For those of you who are here because you're getting extra credit, that's also the place where, to put in your name so that we can get your information back to your professors. That link will not go live until the end of the talk, and it will stay active for 24 hours. Please give us your feedback, especially about the speakers. This is where we get feedback and try to alter programs or see what people are interested in, how people take these sets. So please take a moment to do that for us. I also encourage you to follow us on our website and on Facebook and on Twitter. So a little bit about the Center. The mission of the Center for Public Choice and Market Process is to advance the understanding of economic, political, and moral foundations of a free society. I now want to introduce one of our market process scholars, Nick Catherall, who's going to introduce our speaker tonight.
Good evening. Thank God it's Friday. My name is Nick Catherall, and I'm a market process scholar. Firstly, I'd like to thank the Center for Public Choice and IHS for making this evening possible. With us this evening, we have Dr. John Hasnas. He is a professor of business at the McDonough School of Business at Georgetown University, and he is also a professor of law at Georgetown Law School. Dr. Hasnas received his undergraduate degree in philosophy from Lafayette College and received a JD and a PhD from Duke University. This evening, he will be speaking to us about the First Amendment, and I hope you all welcome him. Thank you.
Thank you. Give me a moment. Okay, it's on, right? I will speak to you tonight. Is that? Can you turn it on?
Yep.
Okay. Now that the technology is set up, I'm able to say that I'm very happy to be able to be here and speak to you. I'm glad to be invited down to Charleston to talk to you about the First Amendment. Thanks for the introduction. My background is in law and philosophy, but I should warn you or give you to set things the stage properly. This is not going to be a talk about constitutional law. So I'm not a constitutional scholar. I don't talk about constitutional law. What you're getting tonight is a philosophy talk. So I'm going to talk to you about the philosophy behind freedom of speech, and I will present what I think is a practical way of looking at the First Amendment. But you should know that there will be no constitutional scholar that I know of anywhere in the world that will present the First Amendment in this way. So you're getting my speculation about the First Amendment and a way in which we could understand it. So, having said that, what I'm going to do tonight, because I said it's a philosophy talk, philosophers present arguments. I'm going to try to present reasons why you should accept a series of 3 conclusions. So here's what I'm going to argue for tonight. I'm going to present an argument for each of these 3 propositions. The first one is that the First Amendment does not guarantee the right to freedom of speech. Second is that treating the First Amendment as though it does guarantee the right to freedom of speech increases the danger of government censorship. And then third, the right to freedom of speech is best secured by interpreting the First Amendment as a limitation on the power of the federal government, but not the state governments. So there's 3 propositions. I'll give you my best reasons for why you should think that they're true. All right, to do that, let me begin. Again, since it's a philosophy talk, philosophers always make distinctions. Let me begin with a distinction. I want to distinguish between the right to freedom of speech and the First Amendment. The right to freedom of speech is a fundamental human right that's possessed by all human beings. The First Amendment is a provision of the United States Constitution that limits the scope of its powers. So first, I'll talk about freedom of speech. To be a meaningful entity, the right to freedom of speech must refer to something other than whatever legal protections for speech exist in any particular legal code. If that weren't the case, then even the most repressive regimes would be one in which there was freedom of speech. It was nothing more than whatever was guaranteed in the law of any particular society. So to be meaningful, the right to freedom of speech must refer to a pre-political right that human beings possess just because they're human beings. The right to freedom of speech is what would ordinarily be called a human right or a moral right. It's the things we have because we're human beings. If a right like that exists, it has to be established on the basis of some sort of philosophical argument or philosophical grounding. So some people will make an argument from a Kantian moral perspective that the duty to treat everyone with respect due to rational beings means that you have to recognize some of their rights. Perhaps more familiarly, most of you are probably familiar with the utilitarian argument for freedom of expression that's contained in John Stuart Mill's essay on liberty. Many of my libertarian colleagues will argue that the right to freedom of speech is a natural right that's just inherent in either the way the universe is created or in human nature. Some theorists argue that there are no such things. There are no such things as human rights or moral rights. All rights are conventional. Human rights are just figments of our imagination. They don't exist. Of course, if there are no human rights, then there's no such thing as the right to freedom of speech either. I'm not going to enter that argument here. Whether there are these kind of rights or not is immaterial. I will point out that if there in fact is no such thing as the human right to freedom of speech, then the First Amendment can't guarantee it, so with regard to that perspective, we're done. Under the assumption that the right to freedom of speech exists and has some meaning, it's got to refer to a moral right that exists independently of law. That means that these moral rights, provide a criterion by which we can judge the quality of a political system or a legal system. If the legal system is one which violates human beings or citizens' moral rights, then that's an argument to say it's unjust and it should be reformed. If a legal system is one that helps protect our human rights or our moral rights, that's an argument to say that the system is functioning properly and is just. These rights serve as a basis on which we can make judgments about the quality of whatever political system we're talking about. So if the right to freedom of speech exists, it's a pre-political moral right on which we can judge the quality of political systems. Okay, so far so good. What does it mean to say that something is a moral right? Well, rights provide their possessors with a sphere of control. They invest the holder with the power to decide how to act for himself or herself. So let's say we have a right to freedom of religion. What that means is someone who has that right gets to make up his or her mind about what religion he or she wants to practice or how to worship God. That decision stays with the individual. If you think we have a right to smoke, that means the individual gets to decide whether or not he or she is going to smoke. If we have a right to freedom of speech, that means each of us has the power to decide whether to express our ideas and how to do so. Rights give us a sphere of control. Rights also invest their possessors with responsibilities. With the power to make decisions for oneself comes the responsibility to live with the consequences of whatever decisions one makes. So if I have the right to freedom of religion, and it turns out that the Catholics are right, and I'm going to hell because I chose Zoroastrianism, yeah, that's on me. It's my responsibility. If I have the right to smoke, then I have the responsibility to live with lung cancer if that results from my decision. And if I have the right to freedom of speech, then I have the responsibility to accept condemnation of others if they think I'm a jerk because of what I say. So rights give you control, they also give you responsibility. All right, I'll ask you to note the following. When rights are divorced from their responsibilities, or rights divorced from their responsibilities, those are dangerous things. So if I have the right to smoke that's divorced from my responsibility to pay for my own cancer treatment, then I'm shifting the cost of my cancer treatment onto other people. If I have the right to make investment decisions free from the responsibility to suffer the losses, then you end up with a savings and loan crisis where what happens is taxpayers end up paying the bill and other people have to suffer the consequences of my decisions. If I have the right to drive that's divorced from my responsibility to use reasonable care, not to harm other people, then the lives of others are put in jeopardy by my decision. So if rights are divorced from responsibility, they become dangerous things. And the implication of that is when rights are divorced from responsibility, it becomes much more likely that people will try to restrict your rights. Right? If other people are going to have to pay for my cancer treatment, they will be more likely to try to prevent me from smoking. If others are going to have to pay for my investment losses, they're going to be much more likely to restrict the kind of investments I can make and to make sure I don't make risky investments. And if others are going to bear the risk of my dangerous driving, they're much more likely to try to prevent me from driving in dangerous ways. So rights without responsibilities are the kind of things that are more likely to be restricted, because that's freedom of speech, right to freedom of speech. Let's talk about the other subject, which is the First Amendment. I'm tempted to make reference to Vince Lombardi was a famous football coach from the old days. You're probably too young to know who he was, but he was a famous football coach. One of the stories about him was when the Green Bay Packers had a particularly terrible game and lost to an inferior team, he was angry, and at the team meeting, he got them all together and he had a football, and just put the football on the table and said, "Let's get back to fundamentals. This is a football." And then he began. And so I tell the story because I'm tempted to do the same thing. With regard to the First Amendment, let's get back to fundamentals. You know, I should have had a little thing here and hold up this way. This is the Constitution. What is the Constitution? The Constitution is the document that creates the power of the federal government. Keep that in mind, because the Constitution is not a libertarian document. It establishes the powers of the federal government to limit the liberty of the citizens of the United States. That's what it does. It has some libertarian features built into it because it contains some limits on those powers, but the Constitution is what creates a strong national government when there wasn't one before. Now, the Constitution was adopted in 1789. The Bill of Rights was adopted in 1791. The Bill of Rights were adopted to impose specific limits on the powers of the new central government. The Bill of Rights is a libertarian document. The Constitution is not. The First Amendment contains a specific limitation on the power of the federal government to legislate regarding what citizens may or may not say. So what that means is, here's the relationship between the Constitution and the First Amendment. That's in the Constitution. It's Article 1, Section 8. That's the section that creates the power of the central government to limit citizens' liberties. It says Congress shall have the power to, and I'll put up the rest later. That's where the government gets the power. That's the Constitution. That's the First Amendment. The First Amendment says Congress shall make no law restricting the rest of it. So the amendment is a limitation on the power. The Constitution creates the power. Okay, now let's talk about the relationship between the First Amendment and freedom of speech. The First Amendment does not guarantee the right to freedom of speech. The First Amendment prohibits the legislative regulation of speech by the Congress of the federal government. There's a perfectly sensible argument that government should guarantee citizens' right to freedom of speech. I can give a perfectly sensible argument. It's a Lockean social contract argument. We go like this. People are insecure in the state of nature. Their rights are not secure. So they delegate the power to use force to protect their rights to the government. And then the government is obliged by the terms of this agreement to ensure that the citizens' fundamental rights are protected. And it's a social contract argument, and therefore the government should protect your rights. That's a perfectly reasonable argument for the power of state governments. But it's not a reasonable argument for the power of the federal government. The federal government was not formed by a social contract. The federal government was formed by the Constitution. That's the document that created the government. The federal government is not a social contract. It's something that was written down at a particular point in time and was created by the Constitution. The federal government is a government of specifically enumerated powers that were delegated to it by the states. And the federal government has only the powers that are expressly delegated to it in Article 1, Section 8. And Article 1, Section 8 does not include the power to guarantee the right to freedom of speech. I can prove that to you. Here's Article 1, Section 8, and all of its clauses. I'm not going to give you enough time to read them all, but trust me, it's not in there. That's all of the powers of the federal government. There's nowhere on the list where it says one of the powers is to guarantee the right to freedom of speech. And by the way, this is not an oversight. The framers of the Constitution knew how to guarantee citizens' rights. In fact, they did so in Article 4. The United States shall guarantee to every state in this union a representative Republican form of government. So they guaranteed the right to a Republican form of government. They knew how to do it. They didn't do it in the Constitution. That's not one of the powers of the federal government. The Constitution doesn't give the federal government the power to guarantee citizens' right to freedom of speech or any of the other fundamental rights because it's not a federal matter. The states are responsible for protecting individual rights. If the states are formed by a social contract, they're the ones that have to do that. The federal government is different. The federal government was formed to do the things that the states couldn't do. It was designed to solve a coordination problem. These things were not a matter of federal concern. So the federal government, the First Amendment, the First Amendment does not and cannot change the situation because the First Amendment does not give the federal government any power. The First Amendment restricts the legislative power of the federal government. Congress shall make no law. The words Congress shall make no law means Congress does not have the power to legislate. It doesn't have the power, it doesn't give it the power to guarantee any right to freedom of speech. Okay, so to summarize what I've said so far, or conclude the first part of my argument, the First Amendment prohibits the federal government from legislatively interfering with citizens' right to freedom of speech. The First Amendment gives the government no power to ensure that citizens' rights to freedom of speech are respected. Therefore, the First Amendment does not guarantee the right to freedom of speech. So that was my first proposition. So that argument's done. Right, so let me start talking about the second proposition. Over the course of the 20th century, the Supreme Court has interpreted the First Amendment as though it does guarantee the right to freedom of speech. To explain how that happened, I'm going to give you a super condensed, brief judicial history of the First Amendment. Okay, between 1791, when the First Amendment was adopted, and 1919, there is no judicial history of the First Amendment. By the time the Supreme Court had established the power of judicial review, Congress wasn't legislating restrictions on speech anymore. There were no Supreme Court decisions on this matter. From 1919 through 1925, the Supreme Court began to interpret the First Amendment to mean that Congress may make some laws that abridge freedom of speech. This had to do with World War I. Congress had legislated restrictions on what people could say. You couldn't advocate not signing up for the draft and that kind of thing, and there were a couple of Supreme Court decisions that came up, Schneck versus the United States and Abrams versus the United States, in which the Supreme Court held that you can punish people for violating these acts. So in some cases, Congress could legislate a restriction on speech. Then from 1925 till 1964, the court began to interpret the First Amendment as though it guaranteed citizens the right to freedom of speech. I'll try to show how. Right. Before 1925, it had been recognized that neither the First Amendment nor any of the other provisions of the Bill of Rights applied to the states. There's a famous case, Barron versus Baltimore. Right. The amendments to the federal Constitution restrict the power of the federal government. They don't have anything to do with the states. They don't apply to the states. But in 1925, in a decision called Gitlow versus New York, the court interpreted the 14th Amendment, one of the amendments that was passed after the Civil War, to restrict the state's power to deny equal protection to the citizens. In 1925, the Supreme Court interpreted Gitlow versus New York, interpreted the 14th Amendment to say that the First Amendment applies to state governments. Here's the language. That's the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law. So in Gitlow, the court says, for present purposes, we may and do assume that freedom of speech and of the press, which are protected from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. So at this point, the First Amendment restricts not just the federal government, but also the state governments. That means that from this point on, the First Amendment is restricting the power of all levels of government. Again, this is a super abbreviated history, so we'll move on to 1964. In 1964, the court again extended the reach of the First Amendment in a case called New York Times versus Sullivan. Sullivan interpreted the First Amendment to restrict public officials' right to sue others for libel. Libel is a common law action to recover damages for the publication of false statements that damage one's reputation. Sullivan ruled that in order for a public official to recover in libel, the public official must demonstrate that the falsehood was published with actual malice. And actual malice legally just meant that the publisher knew it was false at the time it was published or had a reckless disregard for its truth. And this rule that came in out of the Sullivan case was subsequently extended to apply not just to public officials, but to all public figures. Now, between 1925 and 1964, the Supreme Court had given many ringing endorsements to the concept of restraining the legislature's ability to restrict speech. And there's case after case in which the Supreme Court is saying things like, democratic government requires political discussion free from the control of public officials. It's necessary to prevent tyranny. Freedom of speech is necessary to prevent totalitarianism. So there are these endorsements to the need to have free discussion in order to maintain democratic government. In the Sullivan case, 1964, the language subtly changes from the negative, from the need to prevent government interference with speech, to the positive, to promoting debate. So in Sullivan, you get this language. Thus, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. It's no longer that we have to restrain the government. Now we want to promote debate. In subsequent cases, the interpretation of the First Amendment as a guarantee of the right to freedom of speech becomes more explicit. So a few years later, in Curtis Publishing versus Butch, you have this language. It is as much a guarantee to individuals of their personal right to make their thoughts public and put them before the community as it is a social necessity required for the maintenance of our political system in an open society. It's not just that we have to preserve democratic government, we have to protect the right for people to express their thoughts. It is because of the personal nature of this right that we have rejected all manner of prior restraint on publication. The dissemination of the individual's opinion on matters of public interest is for us, in the historic words of the Declaration of Independence, an unalienable right that governments are instituted among men to secure. Right. What's revealing about this is the Supreme Court is citing the Declaration of Independence. The Declaration of Independence is not part of the Constitution. It's not part of the law. The Declaration of Independence says governments should secure rights. The Constitution doesn't say that. In order to have the First Amendment be seen as a guarantee of the right to freedom of speech, the court couldn't cite anything in the Constitution. And so it cited the Declaration of Independence. Okay, I'm going to suggest to you that this way of interpreting the First Amendment is a dangerous way of interpreting it. That seems strange. But from a libertarian perspective, using the 14th Amendment to apply the First Amendment to the states may seem like a great idea. Now, neither the federal nor the state governments can interfere with our freedom of expression. Isn't that a good thing? Well, unfortunately, applying the First Amendment to the states almost certainly ensures that it will be limited in scope and riddled with exceptions. I'll go again through the judicial history. Consider the famous example from Holmes' dissent in Schneck. That's one of the first cases that said Congress could legislate against speech. The example he gave was, everyone would recognize that people can't be permitted to falsely shout fire in a crowded theater. Think about it. If the First Amendment applies only to the federal government, there would be no need to weaken it to deal with that case. Why? Because that's not a matter of federal concern. The states have what's called the police power. The states legislate for the health, safety, and welfare of the citizens. It's the states that will prevent people from falsely shouting fire in a crowded theater. The First Amendment has nothing to do with that because it's not the federal government's job to deal with these things. The federal government does other things. The First Amendment would be read as stating merely that the federal government has no business addressing this sort of local problem. However, if the First Amendment applies not just to the federal government but also to the states, then it means that no government at any level may legislatively address this problem. And that makes it much more likely that the First Amendment will be read to allow exceptions, hence the clear and present danger test. You can restrict speech when there's a clear and present danger, as is presented by somebody falsely shouting fire in a crowded theater. But the only reason why you have to make an exception to the First Amendment is because it's now applying not just to the federal government, but also to the state governments. So the first exception comes in. And that can be generalized. Consider obscene speech, obscenity. If the First Amendment applies only to the federal government, it means it's not the federal government's business to regulate obscenity. That's got to be dealt with at the state level. If the First Amendment means that no government at any level may legislatively regulate obscenity, that makes it extremely more likely that the First Amendment will be interpreted as limited in scope. And indeed, the Supreme Court characterizes obscenity as unprotected speech. That's not the speech that's protected by the First Amendment. Now it's limited in scope. If the First Amendment applies only to the federal government, it means that it's not the federal government's business to prevent the kind of violence that can be provoked by fighting words, by the kind of insults that will produce a violent response. That's got to be dealt with at the state level. That's where criminal law functions. But if the First Amendment applies to both the federal government and the states, it means that no government at any level may legislatively act to prevent violence engendered by speech. And that makes it much more likely that the First Amendment will be interpreted as having an exception for fighting words. And indeed it does. If the First Amendment, I'm generalizing, if the First Amendment applies only to the federal government, it means the federal government cannot legislate against criminal solicitation or criminal frauds, which is done by speech. That's a matter of state concern under the state police power, under the police power. But if the First Amendment applies to the states, it means that no government at any level can legislatively prohibit criminal solicitation or commercial fraud. And that makes it much more likely that the First Amendment will be interpreted as limited in scope, as not applying to speech which is also conduct, which is another limitations on the First Amendment. So applying it to every level of government has produced an interpretation of the First Amendment limited in scope and shot through with exceptions. And that's not all. It's also created the danger of rights without responsibilities. Since 1964, we've interpreted the First Amendment so that it curtails civil lawsuits for defamation. And that interpretation introduces a right without the corresponding responsibility. Okay? There's more than one method of regulating people's conduct. You can do it through the legislature. The legislature can make rules that tell us how we can behave. The other way we regulate people's conduct is through the ordinary underlying common law. Can I say anything I want to? Yeah, the government won't stop me, but if I defame you, you'll sue me and then I will have to pay damages. So lawsuits, common lawsuits, are what restrain our ability to say whatever we want to. They make sure that we behave responsibly. The civil liability system makes individuals responsible for the consequences of their actions. That connects rights with responsibilities. It's an extremely powerful regulatory agency. And what the Supreme Court did was interpret the First Amendment to loosen that restriction. So, preventing the legislative, preventing Congress and even the state legislatures from legislating restricting free expression. Let me make sure I'm clear. Restricting, saying the First Amendment applies to the states and to the federal government, that by itself does not create rights without responsibilities. Individuals are still responsible for the hurtful consequences of their speech on others under the common law rules of defamation. So you have suits for libel, for slander, for invasion of privacy, for incitement, for those kind of things. However, if you interpret the First Amendment to not only prohibit the legislative restriction of speech, but also to curtail individuals' ability to sue at common law for harm caused by the speech, that does create rights without responsibility. So remember, in the beginning of the talk, I talked about the right to drive. If you have the right to drive without the responsibility to use reasonable care for the safety of others, then your rights are much more likely to be restricted. If you have the right to publish whatever you want to, without the requirement to use reasonable care as to whether it's true or false, which is the case since 1964, then it's much more likely that you will not be too responsible in what you publish. And I'll ask you to note the correspondence between the advent of what we now call irresponsible journalism and the Supreme Court decisions. From 1964 on, that's when the National Enquirer starts to become a larger publication. That's where the tabloids come from. Yeah. There's also a reduction in fact-checking before you publish, because now you want to get the scoop, and as long as you're not recklessly careless, you can't be sued. On the same score, consider the reputation of journalists over time. For those of you that are old enough to know who Walter Cronkite was, he used to be the news anchor at CBS News, the national news. There was a point in time at which it was said Walter Cronkite is the most trusted man in America. How are journalists regarded today? They used to be highly trusted. Now they're ranked just about the same as lawyers. So their reputational status has come way down. Is there currently more or less public sentiment in favor of government restriction on the media? Not too long ago, we had the Telecommunications Decency Act. Just think about the attempts to restrict what people can say in television ads with regard to politics today. Campaign finance reform is all about restricting the kind of speech you can make through the media. The application of the 14th Amendment to the states through the 14th Amendment produced a judicial interpretation of the First Amendment that limits its scope, allows for several exceptions. How secure can we be from censorship when politicians believe they can gain votes by advocating it? So for the second part of my talk, I'll summarize it this way. The Supreme Court has treated the First Amendment as though it provides a guarantee of citizens' right to freedom of speech, rather than a restriction on the legislative power of the federal government. That produced an interpretation of the First Amendment that's limited in its scope of coverage and is shot through with exceptions. It also produced an environment in which the media can exercise the right to publish free from responsibility to exercise reasonable care to protect the interests of others, which increased public sentiment in favor of legal restriction on the media. Therefore, treating the First Amendment as though it guarantees the right to freedom of speech has increased the danger of government censorship of speech. That was the second proposition I was going to argue for. Okay, so now let's move on to the third. I'll suggest to you that interpreting the First Amendment as applying exclusively to the federal government is more consistent with the conceptual structure of the Constitution. The Constitution was designed to create a system of checks and balances. I can't say that without pointing out, checks and balances are different things. Checks are one thing, balances are another. Again, the lawyer in me makes me say that. Okay. Federalism is one of the balances. Federalism means a division of power between the federal government and the state governments. Power was separated not just among the branches of the federal government, but between the federal and state governments. The federal government gets the powers enumerated in Article 1, Section 8. The states keep the rest. That's the way it was set up. Criminal law was left in the control of the states. The federal government was not given the power to directly regulate the activities of the citizens with regard to matters of health, welfare, and safety. The police power stayed with the states. Reading the First Amendment as a prohibition exclusively on the federal government's power to regulate speech is consistent with this structure. It does not assert that there's no power to regulate speech. It asserts that if there is such power, it's the type that remained with the states. This interpretation allows us to read the First Amendment as an absolute, exceptionless ban on the regulation of speech by the federal government. Think about it. The reason the First Amendment became limited in scope and shot through with exceptions was the need to deal with problem cases such as falsely shouting fire in a crowded theater, obscenity, fighting words, criminal solicitation, and commercial fraud. But if the First Amendment is interpreted as applying exclusively to the federal government, it's not confronted with any of these problems. These problems may all be addressed at the state level where the police power resides. The First Amendment says only that the federal government does not address these problems, not that they may not be addressed. This means there's no problem with treating the First Amendment as an absolute ban on the regulation of speech by the federal government. We don't have to have any exceptions. Okay, I know what you're thinking. Who cares if your speech is restricted? Who cares whether it's the federal government or the state's doing it? What you want is freedom of speech. So if the First Amendment only applies to the federal government and then the states get to restrict your speech, that's no good. However, what you should know is it's completely unnecessary to apply the First Amendment to the states in order to protect the right to freedom of speech from restriction by the state governments. The fact that the First Amendment does not protect the right to freedom of speech from state governments does not imply the right to freedom of speech is unprotected. The First Amendment is not the only way of protecting the right to freedom of speech. The right to freedom of speech can be protected by state governments and by state constitutional provisions, and in fact, it is. So here's some evidence. That's the Virginia Constitution, Article 1. Right? The freedom of speech and of the press among the great bulwarks of liberty and can never be restricted except by despotic governments. So, First Amendment, Virginia has its own First Amendment. Pennsylvania has its own First Amendment. New York has its own First Amendment. California has its own First Amendment. Florida. We already have protections for freedom of speech at the state level in the state constitutions. There's no need to interpret the First Amendment to apply to the states in order to get the protection that we're interested in. The rights also protect, even if it wasn't in the constitutions, the rights also protected by the federal structure of our government. One of the things that is guaranteed by the Constitution is open borders among the states. You can travel among states. They can't close borders. That means everybody gets to vote with his or her feet. If one state becomes so restrictive that you don't like the fact that you can't express yourself anymore, you can move. It's not that hard to move from New York to New Jersey or from North Carolina to South Carolina. The Constitution guarantees open borders. And that makes it relatively easy to escape a state that one doesn't like. Applying the First Amendment to the federal government makes it less likely that the right to freedom of speech will be divorced from, and last point, having the First Amendment apply only to the federal government also makes it extremely less likely that the right to freedom of speech will be divorced from its responsibilities. Okay? Libel, slander, invasion of privacy, incitement, all of these are matters of state law. If the First Amendment doesn't apply to the states, it cannot undermine the state common law that connects the right to freedom of speech with its responsibilities. And there's good reason to believe that the state governments are less likely to undermine the connection between rights and responsibilities than the federal government is. And that reason is written into the state constitutional provisions. I'm going to give you the same thing again with highlighting. That's the Virginia First Amendment, but blah, 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 being responsible for the abuse of that right. That's in there to say, but we can sue at common law for defamation. Pennsylvania, being responsible for the abuse of that liberty. New York, being responsible for the abuse of the right, being responsible for the abuse of the right, but shall be responsible for the abuse of the right. The state constitutional provisions guarantee freedom of speech from government intervention and also say that you've got to use it responsibly because otherwise you could be sued at common law. So to wind up, I'll ask you to make a comparative assessment. Restricting the application of the First Amendment to the federal government means there's no single mechanism for protecting the right to freedom of speech everywhere in the country. You have to protect freedom of speech in all 51 jurisdictions, 50 states and the District of Columbia. Well, that's true. No one said that the fight to preserve liberty was supposed to be convenient, but is it really a good idea to argue that federal power should be used to impose what we consider the just result on everyone in the country? Actually, that sounds more like a liberal or conservative argument to me than a libertarian argument. Is it really a good idea to argue that federal power should be used to impose what we consider, I'm sorry, I just said that. Is there really any reason to believe that speech should be protected to the same degree and in the same way in Provo, Utah, and in San Francisco? Is there value in the concept of the laboratory of the states in which different rules can be tried and we can learn from the experience which ones are most effective at producing peace in different locations? That's the theory of federalism. You have different jurisdictions and they get to try different rules. And we learn from that which ones work. Even if it becomes somewhat more difficult to protect the right to freedom of speech against state governments, the greater protection gained against the federal government is worth it because the federal government presents a much greater threat. The federal government is more powerful and it can impose one rule on all across the entire country. I guess the best example that I can use in present day is it's a big campaign issue about whether we're going to amend the First Amendment to allow the government to restrain people from spending money to make political speech. We have political ads. Campaign finance reform movement wants to make it so that the government can regulate what you can say about political matters. That to me seems much more dangerous than the problems that may happen at the state level. It's also much more difficult and expensive to organize political opposition to repressive measures at the federal level than it is at the state level. Do we really want to place the fate of everyone's freedom of expression into the hands of one court of 9 people with President Hillary Clinton on the horizon, who will be making the next appointments? If you make a comparative assessment, I believe it can look better to have have speech a matter of state regulation, even in all 51 jurisdictions, than it is to have it a matter of federal regulation. Right, so to sum up or to conclude, this is my concluding summary. Limiting the application of the First Amendment to the federal government provides much greater protection against federal regulation of expression than the present interpretation. Because you get an exceptionalist First Amendment. It's not necessary to apply the First Amendment to the states to protect the right to freedom of speech against state governments. It's already built into their constitutions, and open borders means we can move, so we can vote with our feet. Limiting the application of the First Amendment to the federal government better preserves the connection between the right to freedom of speech and its responsibilities, because there'd be no reason to limit common law suits for defamation, and built into the state provisions is a responsibility clause. And therefore, the right to freedom of speech is best secured by, I don't know what I just did. How do I go back? No. Okay, there we go. Okay. Therefore, the right to freedom of speech is best secured by interpreting the First Amendment as a limitation on the power of the federal, but not the state governments. That's my third proposition. All right. I've given you an argument for all three propositions. This is my speculation on the way to interpret the First Amendment. It is not the way the First Amendment is interpreted by any living, functioning constitutional scholar today. It's a philosophical argument for a way of looking at things. So with that, I can entertain your questions and objections. Yes, sir.
So a lot of your stuff here, like you said, I've heard this argument before, so it's very interesting. One thing
I'm sure you've never heard this argument before.
one thing I would ask, it seems as though a lot of this relies on a level playing field for different demographics in the United States. I think when it comes to people like African Americans and women who have traditionally not had as much of a voice, if it's left to each individual state, certain states who have had traditionally more oppressive political regimes towards women and African Americans wouldn't be held accountable in allowing those people to have a voice of their own, so the federal government would be the only entity to be able to enforce that.
Yeah, that's a reasonable thing to be concerned about. In the past, there have been highly oppressive measures in certain state governments against African Americans. They never were about speech. They didn't care what they said. They were going to repress them much more seriously. So it's something to be concerned about. But if you've got protections that mean that people can't be oppressed with regard to where they can go, how they can work, how they can make a living, where they can go to school, and all that's left is we might try to curtail the speech rights of people based on their racial characteristics. We're in a territory that's not very harmful, but you can't do it anymore. The 14th Amendment does apply to the states. The 14th Amendment guarantees equal protection of the law, and the 14th Amendment is designed specifically to protect insular minority groups. So the 14th Amendment takes care of that. Sorry. I guess I have to stay back here. The 14th Amendment takes care of that. The First Amendment is about freedom of speech. Freedom of speech is not at risk in this way because the 14th Amendment takes care of the case that you're concerned about.
So in regards to that, like, you basically argue that the federal government could be responsible for enacting laws that establish better economic development or upward mobility for African American women, and then along the way they will be have more access to speech.
Be careful. Like the 14th Amendment means states can't pass laws that disable or work against any particular group. It doesn't have anything. Again, the amendment, the 14th Amendment is an amendment. An amendment, it restricts power. It doesn't create any power. So the 14th Amendment doesn't say that the government can do anything to help people who need help. That power is going to have to come from somewhere else. You're going to have to find some place in Article 1, Section 8 where you're allowed to do that. Now I know where it is. It's in the Commerce Clause. The Commerce Clause lets Congress do whatever it wants. The Commerce Clause is a blank check. Okay? It says you have power to regulate commerce. That's why we have the Civil Rights Act. Because the civil right, you can't segregate restaurants because the food people serve at restaurants moves in interstate commerce, and that's the source of the power to regulate these things. So the Commerce Clause, the way it's interpreted, gives the federal government the power to do anything it wants. But whatever it does, neither the federal government nor the states can do it in such a way that it doesn't give equal protection of the law to all groups. So minorities are protected by the amendment, and then you're going to have to make an argument to the federal government as to what it should be doing to improve welfare. But no matter what it does, it's got to do it fairly to all groups. If it's a reasonable concern, I don't think it interferes with the thesis I'm presenting. Other questions or objections? There has to be objections. You can't think this is right. Yes, sir.
I'm not such a scholar, but how would this differ from what the Federalist Society would say? I mean, they would say generally, let's strictly interpret the Constitution. The Constitution says do not make any laws. It doesn't say that there is a guarantee. So wouldn't they say the same argument you're making?
No, they don't. I mean, I'm a member of the Federalist Society.
Can you explain why?
Because this is too crack-brained. Because the Federalist Society is not, they're not a philosophy society. They're a society of lawyers, and they want to make arguments that can actually have an effect on the way our legal system is organized and functions. So they have to stay within the limitations of what is constitutionally acceptable today. So they're going to argue for original intent as the way of interpreting the Constitution. And sometimes the Federalist Society will try to read the words very, very strictly, except for when it serves their interest to read it very, very broadly. But it's not as though they're consistent. The Federalist Society is all in favor of original intent. And yet, they think that they often argue that the 14th Amendment requires government to be colorblind. We know that's not true because the same Congress that passed the 14th Amendment also passed an act that only applied to freedmen, to blacks. So that Congress itself wasn't colorblind. So there's lots of things going on in the Federalist Society, but they are constrained to make arguments within the current way of interpreting the Constitution. And everyone agrees that the First Amendment does go through the 14th Amendment and apply to the states. So if they started arguing that no, it should be restricted to the federal government, no one would listen, they would have no effect. They can't undo what happened in 1925. So they're just more realistic than me. I'm presenting a philosophical lecture to you about how we could get more protection for freedom of expression if we thought about things in a different way.
So, incumbent on this argument that, I think this is the argument that free speech is better regulated by civil defamatory lawsuits than it is by one sort of sweeping provision in the Constitution. Don't you think that that sort of limits anyone saying you can only say things that are patently true, and if anyone has any standing to say what you're saying is not true, what could follow is a lawsuit, and you kind of get mired, and people will constantly make lawsuits unless you make like an objectively true claim, which is very difficult to do.
Well, you're characterizing it in a negative way, but I think that's a great thing. I can say whatever I want to. I can say anything I want to, but if I carelessly or intentionally say things that are false, that cause damage to another member's of society, reputation, or cause them a loss of business or something else like that, I can be sued and have to pay compensation for my harmful behavior. The common law, civil liability, the common law of tort is the great regulatory force in our society. We have an immense amount of freedom to do whatever we want to, but we have to be careful not to hurt other people. I can drive, but I have to use reasonable care. I can operate machinery. I can make saws that people use, but I have to be careful that when I make them in such a way that people don't cut off their fingers. And I can even say anything I want to, but there's some limits to what I can say because other people have interests that are worthy of protection. And the nice thing about the common law is it evolves in response to what juries decide. And there's a lot of lawsuits for defamation that get nowhere because juries don't go there. I have another talk for you all tomorrow, which is going to be about the common law. And that ends with a discussion of defamation and one of the most important defamation cases, which I'm going to argue to you was one of the greatest blows for liberty that happened over the course of my lifetime. So I'll wait till tomorrow for that. But you're right. Defamation lawsuits restrict our ability to say anything we want to. in order to protect the interest other people have in their reputation.
Could I ask a follow-up?
Yeah.
So could you then, in theory, sue me for defaming your position by mischaracterizing it because you didn't view it as passing through? And then, maybe you can afford a lawyer, I as a college student cannot, I have to pay damages
Yeah.
to you.
I can sue you. Yeah, I can sue you, and it can be a frivolous lawsuit. And the reason why I won't is because I'm going to incur a lot of costs. And the reason why you don't have to worry about it is because the nice thing about our civil liability system is sorry, I'm not saying this in a way that, I sue you if it's frivolous. I'm sorry to say this, you do need a lawyer these days. But you can get it kicked out of court on a motion for summary judgment. If what you say is true, it gets nowhere. Truth is a complete defense. And the other thing is, the fact that I have a different interpretation of it doesn't mean anything. All you have to do is walk in with that. Perhaps the best evidence of this is Bill Clinton. You guys don't remember, but the older people remember. Bill Clinton was accused of perjury, and it was part of his impeachment. And his defense was, the older people remember this, it depends on what the meaning of the word is. Why? Because he was asked whether he was having sex with Monica Lewinsky. And the answer was no. When he was asked that question, he wasn't having sex with Monica Lewinsky. They didn't ask him, have you ever had sex with Monica Lewinsky? And therefore he didn't lie. The law is that much of a stickler for truth. It's not a matter of interpretation. You have to prove falsehood. So I can bring as many cases as I want. From Donald Trump, I might do that just for nuisance value because I'm making you incur costs. But most of us don't have the money to spend in wasteful lawsuits like that where it gets us nothing. If you want to, tomorrow we can talk about the needs for certain types of reform to the tort system to make it so that this is not a problem. But here's your choice. You can have regulation of speech to protect people's interests through civil liability, or you can have regulation through the government. You can have regulation. Which one will you pick? Especially this is an easier argument to make today when you've got the entire Democratic Party arguing that we should basically repeal the First Amendment. Do you really want that to be the source of regulation? Yes, sir.
So back in 1925, when the Supreme Court said that the 14th Amendment applies the First Amendment to the states, what kind of problem was the Supreme Court trying to solve? And how would your approach deal with that problem?
The problem was that the state governments, you didn't have the Bill of Rights, didn't apply to the states. Right? The Supreme Court wanted to fix things. So it just said, okay, we'll apply the Bill of Rights to the states through the 14th Amendment. It can do that because it's the federal government. What the people who were concerned about any of the issues had to do was they had to bring lawsuits at the state level through the state Supreme Courts, which had to apply their own First Amendment. And in many states, the decision went one way, and in some states it went another way. If you're in a state in which there's some kind of repressive government in place right now, you might get the wrong result. The Supreme Court just wanted to make sure everything was good everywhere, because the Supreme Court didn't believe in federalism anymore. Federalism was a balance that was supposed to check the federal power. This simply got rid of that balance. It said, we'll do it all. And it's easy for me to make the argument now because it's after the fact. But at the time, nobody saw this as any kind of problem, right? Bill of Rights are great, let's have them everywhere. They just weren't thinking in terms of the protections you get from federalism. I don't want to claim any kind of brilliance here. I can see what happened because I know what happened. At the time, what could be wrong with saying, we'll just apply the First Amendment to the states? Looked like a good thing to do. Yes?
So if all the states had First Amendments, wouldn't the 1925 decision just say, hey, we're going to interpret your First Amendment this way?
No,
This
no. The federal government doesn't get to interpret state constitutions. What happens is you bring a suit at the state level, you go to the state Supreme Court, you get an interpretation. To get into federal court, you can get into federal court two ways. One thing is you can pose a federal question. The other thing is you can have a lawsuit between people from different states. So there's either diversity jurisdiction or federal question jurisdiction. So these matters would be handled at the state level. It shouldn't come to the federal government. How can it come to the federal government? Well, once the 14th Amendment means all of the Bill of Rights flow through it and apply to the states, all of a sudden, everything's a federal question. Right? The 14th Amendment's a federal amendment. Now, all of these lawsuits, which could or should be brought at the state level, go into federal court. Why would you want to do that? Well, you've given us the answer. At a particular time in history, the federal courts look like a much more impartial, better forum for your decisions. And even coming right up to close to the present, federal judges usually have a higher status and more respect than the state judges, partially because of the difference between being elected and being appointed, and longer terms. But people would rather get into federal court, but you can't get into federal court unless it's a federal question. And the Supreme Court in 1925, it's not that far removed from, it's in the middle of the Jim Crow era. It's not that far removed from the Civil War. It doesn't trust the southern state courts and judges to do the right thing. Federalism is supposed to allow you to vote with your feet and to have different rules in different places. But if the rules are immoral enough in certain places, or the enforcement is biased enough, there's this desire to fix it. And who can fix it? The good guys in Washington can fix it. And that's probably why they did all this. It's understandable. But the result is, in the 21st century, we don't have that much protection for freedom of speech left. We have protection for lots of speech, but not for obscenity, but not for certain kinds of criminal fraud and things like that, and most especially, not for political speech. Campaign fund. The most vilified decision of the last decade is Citizens United. What did that say? That said, corporations can pay money to place political ads. What's being attacked now directly is people trying to influence political outcomes. That's what freedom of speech is supposed to be for. It would be better if the First Amendment meant Congress shall make no law abridging freedom of speech. Congress, worry about it at the state level. If the First Amendment was interpreted in that way, we would not be in the middle of campaign finance legislation arguments about who can speak and why. And it's not just that. We've got John Doe warrants being issued to people who are trying to raise money to make political ads because of their illegal potential coordination. There's all kinds of ways of suppressing speech if these laws can be on the books. Anyway, that's my best attempt to explain it.
I'm assuming, hopefully correctly, that in addressing the supremacy of states to determine freedom of speech, that a lot of the expressions of speech would take place within that state, like a state newspaper or a local newspaper. What about when addressing groups like Occupy Wall Street movement or hacker groups like Anonymous that cross state borders?
Yeah, but it doesn't matter, right? You publish in a state, I publish something in a state that defames somebody outside of the state. The person just sues me in the state. There's no rule that says people from New Jersey can't sue for injury done them in the New York courts. You just sue.
Well, something like technology being involved, like Anonymous, they don't necessarily post, there's no IP address, or unless you were to sue for something based on their IP address. How do you sue that?
It's hard. I gave a presentation tonight. Here's the bottom line of my presentation. The reason why we made the First Amendment apply everywhere is because we're lazy and we don't trust the way the Constitution was set up. We want it to be easy. We're libertarians. We want a rule that says everybody can have freedom of speech everywhere and it's guaranteed. And you know what? Look, there's even one place to go to make sure it's guaranteed. That makes life easy and we feel good. The alternative is hard. you have to actually try to protect freedom of speech in all of the different jurisdictions. And if you fail in one place, you have to rely on people being willing to move. It's a fight, it's a struggle at all levels. And, you know, that's to protect freedom. I shouldn't stand up. That's to protect freedom of speech. As far as regulation goes, I want regulation that comes from civil liability. I want it to be responsible. But it's hard to be, sometimes it's too easy to bring lawsuits. Sometimes it's hard to bring lawsuits because of technological problems. There's an interesting, this is going to be tomorrow's talk, but there's an interesting feature of our civil liability system. Again, to compare civil liability with government regulation through the government, if you want problems solved by the government, then you have to pick some people who you think are smart and say to them, fix it. You make the rules, and you just do whatever you think is best. On the other hand, if you want to regulate people's behavior through civil liability, you don't have to do anything except allow attorneys to recover on a contingency fee basis. And then you end up with an army of private regulators who are trying to make sure that nobody does anything that harms anybody else, and will bring lawsuits at their own expense to make sure that we have a safe environment, because it's in their own interest. It's hard. Yeah, if it's hard for you to protect people against this kind of thing, who do you want to do the protecting? People who aren't even interested in this in Washington, D.C., or a bunch of people who are going to figure out innovative ways to try to track down the wrongdoers so that we can get our payday by bringing a successful lawsuit. I am a libertarian, and I'm in favor of safety, health, and welfare regulation. It's called tort law. It's just not done by the government. And the reason why I'm in favor of it is because it's effective. It's much more effective. It's effective, and not only is it effective, it doesn't infringe on our freedom beyond what's required to prevent people from being harmed. Nobody brings a lawsuit without harm. It's libertarian regulation. If you're a libertarian, you think that people should be stopped from harming others and allowed to do anything else. That's tort law. Why in the world, see, I'm giving tomorrow's speech, why in the world would we say to the government, regulate this, when we've got a powerful system which people are complaining about being too powerful as it is? So it's a problem, and I'm pretty sure one of my plaintiff lawyers colleagues out there is right now working on solving it. Yeah.
So
I'm afraid to walk over that.
To Josh's point, so what if, I'm in New Jersey and someone in South Carolina, the law there is very different, much looser, defames me? What standing do I have to sue this person who's operating out of South Carolina where they're sort of permitted to say whatever they want?
Okay. This will be an unsatisfactory answer, but we have 51 jurisdictions in the United States. They have different rules of law. How do you know what to do when people from one state are in a lawsuit with people from another state? Whose law do you apply? What do you do in cases like this? The reason why it's an unsatisfactory answer is because there's an entire body of law called conflict of laws that's designed to answer exactly this question. And when you go to law school, tort law is the first year course. You get that first so you understand what the law is. Then when you're in your second or third year, if you're interested, you take the course called conflict of laws that tells you how these things are resolved. But because it's something that developed at common law as well, for it to be successful, it had to be something that would compose disputes, that would make people satisfied. So it won't be a system in which people get to haul you into their court because the rules favor you and are inconvenient. The rules of conflict of law work. There's a real problem in the tort system. There are places that are known as tort hellholes. Right? This particular area is always going to find liability against corporations from New York, down in Alabama, there's areas. So the problem is with the jury pool there. There are real problems with tort law, and it being, in the sense that it can be too highly regulative. There's almost no examples where the problem is it's not regulative enough. And what you do in cases like this is the rules of conflict of law tell you how to resolve it. that's not my area of expertise. I know enough about it from the old days when I was in law school to know that if you can't get justice in one state's court, you'll be able to bring it in another one. And this is fun for me because I gave a talk on the First Amendment and the Bill of Rights, which is not my field. It was a completely speculative philosophical talk, but all of my questions, the questions you give me, are about the things I know about, which is tort law. That's what I teach at Georgetown. That's what I'm interested in. And maybe it's because I'm offering it to you as the alternative. If you have freedom of speech, that's fine, as long as it's responsible speech. And the mechanism in our legal system that makes sure speech is responsible is defamation law. And it's not up there anymore, but at the state level, the state constitutions have written into their version of the First Amendment that the speech has to be responsible. And the reason why our First Amendment doesn't have that in there, this is also revealing. The reason why our First Amendment doesn't have it in there, because it doesn't have to. Right? The federal government doesn't have any power to infringe on speech, and libel and slander is state common law. It's got nothing to do with the federal government. Of course, the First Amendment only has to say, make no law. It doesn't have to worry about responsible speech because it's not a federal matter. The First Amendment is different than the state level comparable amendments because defamation is a state level matter and there's nothing similar at the federal level. It's another indication that the amendment was supposed to be interpreted the way I'm suggesting, even though since 1925 that's off the table. Okay, the same people have lots of questions. You want to go again?
It was just a continuation on that point. Do you think that in regards to conflict of laws, it should look something like the way the international legal community operates, where if someone commits some kind of legal wrong in one country, they're brought before the court in that country, where it's decided between the two courts of each country?
These are really interesting questions. Really interesting questions, difficult to answer, and my answers are always unsatisfactory because here's my answers. I'm not smart enough to know the answer. So what I need is a mechanism that will teach me what the right answer is. And that mechanism is a trial and error mechanism that we refer to as a common law process. Now it could be that we have enough trial, because there's no world government, these things on the international level have to be settled through some kind of agreements. They have to figure things out. And if they try a lot of different things, they'll find out perhaps what works best. The problem with the international level is it's not really solving the problem, it's governments making decisions. And you're arguing about governments. The nice thing about the common law system here is the disputes are always between individuals. And by having a lot of trial and error, we end up with rules that stick because they solve the problem and people stop arguing about it. When you have rules of law in a common law system that don't work well, you keep getting more lawsuits about it. And then finally somebody comes up with a solution that seems to make people work together without conflict, and then the law sticks. I teach tort law, so I start with intentional torts. I got a case from the 14th century. I got a case from the 18th century. Because those rules, we figured out a long time ago what those rules are, they still work. When I start talking about things like, one of the cases that I just did is on whether spam counts as trespass to property. You know, is that enough of a kind of, we don't know the answer to that question. Well, we do because that's a 1990s case. But at the time, we didn't know the answer to the question. And what we needed was a mechanism that would teach us. So that's what common law does for us. It's a good question, it's complex. I don't know the answer, but I know enough to know neither I nor anybody else should be deciding what the answer is. This is something we need a trial and error learning process to figure out. And the reason why the rules of common law are so good is because they've been going for hundreds of years, and the ones that last are the ones that work. And the stupid ones get washed out. Do I have more time or are we? Okay, so I have no more time. We're done. Thanks.